Ms. Kuik Shiao Yin.
There are three groups of vulnerable employees I will cover in this cut: women, foreign domestic workers, and people with disabilities. First, women. In a November 2017 article, Straits Times interviewed a 28-year-old female lawyer whose former boss repeatedly harassed her. And after she rejected him again and again, her boss shifted her work away from legal work to menial tasks. And though she reported her situation to all the appropriate levels of power, she was met with cultural roadblocks: a female senior colleague who told her to stay silent, a founding partner of the firm who brushed it off as such things happen when you're a pretty girl, and a human resources department who advised her not to make a fuss. So after a year of feeling trapped, she confessed her story to her father, who was also a lawyer, who insisted that she make a police report. And scared for her future career prospects in law, she chose to inform the firm of her intentions to go to the police. The firm finally dealt with the matter by getting her to sign a non-disclosure agreement, prohibiting her from reporting the matter to the police. In exchange, she received a year's salary, and she had to leave the firm immediately. And the article said nothing further about the boss, so for all we know, he's still out there harassing his employees. So the female lawyer told the reporter, "I'm not someone who doesn't speak her mind, but when I spoke up, I was told I'm a liar and I made things up. I hope that more people don't have to feel alone and they can find some support." So what is troubling about this story to me is that if a relatively well-resourced and legally trained employee with the support of a well-resourced and legally trained parent felt that helpless in the situation, then how much more difficult would it be for an employee with less power and resources to seek help? So can the ministry consider two ways of enhancing protection of women from workplace harassment? First, the tripartite advisory to manage workplace harassment is useful, but there is no awareness about who is actually meeting those guidelines. So can the ministry consider having a public register that actually tracks which companies are adopting the measures suggested in the advisory? And second, because it is usually too complicated, expensive, and ultimately pretty awkward to get a court order against a colleague or boss, most victims don't bother with getting a protection order. And some victims also rather not immediately escalate their situation to the police because they are uncertain about the impact on their personal safety and professional reputation. So harassment victims could benefit from having a safe and trusted third party with institutional authority to help them deal with their situation. And currently, TAFEP is an educational body, and a tripartite alliance for dispute management and the employment claims tribunals deal with more straightforward claims like salary disputes. So can the ministry consider empowering either TAFEP or the other two bodies to deal with workplace harassment grievances, or have its hotline for reporting labor infringements be extended specifically to workplace harassment as well? On foreign domestic workers, according to a March 2017 Singapore Law Review article, the MOM's Employer's Guide is a good step, but some of the language used in there is still a bit ambiguous. So right now, words like should and must are used interchangeably in the guide, but should is an aspirational goal, whereas must sounds like an indisputable requirement. So for instance, the guide uses should for your foreign domestic worker should not sleep near any dangerous equipment or structure that could potentially cause hurt or harm to her. And you and your foreign domestic worker should mutually agree on which day of the work she should take the rest day. But uses must for you must provide your worker with 3 meals a day, and you must minimally provide your worker with a mattress, pillow, and blanket. But if we believe in worker safety and workers' rights, then surely our domestic workers must sleep in safe quarters and must mutually agree on their rest days. So can the ministry replace should with must in the guide wherever appropriate? This would help lessen public misunderstanding about what is MOM's tolerance level for abuse that an employer can get away with. Lastly, on people with disabilities, the Employment Act does not define what unfair dismissals is, leaving room for misunderstanding. So people with disabilities have been dismissed without explanation by their employers. Can the ministry amend the Employment Act to provide clearer definition of what constitutes an unfair dismissal and set out legal remedies for unfair dismissals? And since our workforce is rapidly aging, acquired disabilities such as mobility issues and sensory impairments will become a growing challenge. Some employees also acquire a disability while working for a company. Currently, there is no requirement for a company to accommodate the employee's changed situation, such as redesigning a job or offering an alternative role. So can the ministry require or assist employers to provide reasonable job accommodations for employees who acquire disabilities in the course of their employment so that they may continue in their current role wherever this is possible or appropriate? Thank you.